Good afternoon, everybody, and a very warm welcome to yet another webinar brought to you by Saiosh. My name is Niels Norkier. I am the Chief Executive of Saiosh, which is the South African Institute of Occupational Safety and Health. We are a SAQA recognized professional body that register occupational health and safety practitioners in South Africa. Currently, we have 3 professional designations that is registered on the NQF, namely technical member, graduate member, and chartered member. Our current membership database is in excess of 18,500 members. We are hosting these webinars for our members on occupational health and safety. We got a slogan that says Saiosh keeping you informed, and this is exactly what we do. This morning's webinar is possibly one of the most important webinars that the health and safety fraternity is going to attend because it's not every single day that a complete new act, an amended act in occupational health and safety see the light. Just for our members to note that this webinar is CPD verified by Saiosh. So after the webinar, whether you are viewing it live at the moment, either on the webinar channel or on our YouTube channel, or whether you view the recording at the later stage, is CPD verified, and members can claim the CPD point from their profile. Members should know how to do that. If not, just go to the website and search for the CPD page. There's even a video tutorial to show you how to claim CPD points. Just some housekeeping announcements before we start this webinar this morning. Please note that the Q&A will be open this morning. I plead with you with the number of persons that registered for this webinar, which is in excess of 1,500, that you post only questions relative to the bill, the Occupational Health and Safety Amended Bill that the Chief Inspector will be discussing with us this morning, and also relevant to what the Chief Inspector obviously present. It's humanly impossible this morning to actually attend to all the questions. It's also unfair to the Chief Inspector that we actually ask him every single question that we get there. We will have afterwards, one of our chartered members is online, and we will summarize some of the questions and post maybe 5 or 6 to the Chief Inspector afterwards. But please, if you do have a burning question, feel free to post it in the Q&A. The chat box is open for exactly what it is, for chat. Please feel free to meet, greet, thank Saiosh, whatever the case will be, compliment, whatever the case will be. Also post any issues that you might have technically. If you, for example, don't hear the sound or whatever the case will be, please feel free to put it in the chat box. We have our communications and membership manager, Gareth, in the background. He will endeavor to make sure that this webinar run as smooth as possible, even though we're experiencing difficulties in South Africa at the moment with fiber lines and internet, but we will do our best to give you a smooth webinar. If you have missed any of our webinars, including this one, you will find it on our website. All our recordings of our webinars are there. I think this is about webinar number 22 that Saiosh has hosted, so you can find it there. This particular webinar is also recorded, and the recording will be made available to our members within 48 hours after this webinar. On all our platforms, it will be sent to you directly as a member via email. It will also be available on our Facebook and also on our website. Right, and then also please note that the webinar is full this morning. So if you have colleagues that may be contacting you and saying that they can't get in, please inform them that this webinar is also live streamed on our YouTube channel. So, and that has got no capacity. So the whole world can actually attend if they want to. Right, just before we get to the introduction of the Chief Inspector to talk to us this morning, I thought I would take out a little section out of an article that I wrote about 2 or 3 years ago for the Czech Management magazine, which is a nice lead up to where we are today with the current legislation. In the early years, from about the First World War, it was recognized by the South African government that too many serious injuries and fatalities were occurring in the workplace. The war effort had caused high production and desperate measures to turn out armaments according to the demand. In an effort to control this, the Factories Act, Act number 28 of 1918, was promulgated, which set standards for the South African industry. During the Second World War, the Factories Act was improved on and replaced by the Factories, Machineries and Building Works Act 22 of 1941. This act placed duties and responsibilities on users of machinery, occupiers of factories, as well as builders. Some 40 years later, we saw the introduction of the Machinery and Occupational Safety Act, Act 6 of 1983, commonly known as the MOS Act. I'll never forget when I started my health and safety career at Eskom, at the brand newly built Kendall Power Station. One of my first tasks in that time was to change the old Factories and Buildings Works Act C regulation appointments, factory manager, etc., to the new appointments in terms of the MOS Act. Followed 10 years later by the Occupational Health and Safety Act, Act 85 of 1993, which is obviously our current act. What was notable about this act, which is currently in place, is the introduction of occupational health. Today, 28 years later, we have the Occupational Health and Safety Amendment Bill, which was promulgated on 14th May 2021, and a subsequent gazette that came out calling for public comments, which Saiosh has forwarded to its members. Just on this point, Saiosh has appointed its own technical committee, which will review the Act and submit collective comments on behalf of Saiosh members to the Chief Inspector. There is a platform open on our technical forum where members can go and post their comments, and we will consider all reasonable comments that's in there and submit it to our own technical committee before we send it through to the department. It is interesting to note that all current health and safety related acts in South Africa are post-democracy, barring the current Occupational Health and Safety Act, which is the OHS Act we got now. So it is my humble opinion that it's high time for a new Occupational Health and Safety Act in South Africa. To discuss this morning and to go through the amendments and the changes to the Occupational Health and Safety Act, we are honored, pleased and privileged to have the Chief Inspector with us. Our members, I believe, is also honored and can be honored and pleased, and because Mr. Zana is the first, we are the first group that is addressing on this amendment act. So if I can ask you, Mr. Zana, if you can please just put your camera on at this stage so that I can see that you're on that side, and welcome you. There you are, sir. Thank you very much. On behalf of Saiosh, I'd like to thank you for your time and effort this morning. I think it's necessary to hear from the Chief Inspector about this bill and the amendments, and possibly the thinking behind some of the changes, and I would say to put the safety fraternity at ease and maybe discuss the need and the necessity of some of these changes. We thank you for your time. Good morning, sir, and over to you. If you can share your screen, or if you just want to start talking first, I really appreciate it. Thank you and enjoy the presentation.
Thank you very much, Mr. Nokia. From the Department of Employment and Labour side, we of course do appreciate the opportunity always afforded us. So we are grateful for this interaction with the members of Saiosh and all other members or people who have joined. I think the important thing of this particular bill is it's been a long time in the making. And the fact that it has now come out, we are most appreciative of the fact that we can introduce some of the changes that have been taking place in the environment. So from a health and safety point, this particular bill is quite important, and your comments are going to be quite critical for us to make sure that when we do put out something, that we do put out something that is relevant. So legislation that is not relevant is always a problem. And I think, as I always allude to, the greatest challenges that we have always is on the implementation. So well thought out comments that we know it will work when it's implemented is actually quite crucial. I think Mr. Nokia has done a good introduction in terms of where we find ourselves in terms of the acts in South Africa and where this bill fits in. And this bill does introduce a couple of interesting things. So without much ado, we'll get down to it. The critical thing is I'm going to do two documents. The first one is this presentation. Mr. Nokia asked me how many slides do I have? I have about 500. Not really, Mr. Nokia. But we have a couple of slides here, and then I'm going to revert to the document. You are going to have the document with you, so I thought it would be quite prudent that we work off the document itself so that you can have a look at where it is. I basically captured everything in the presentation, but I don't think that I'm going to keep talking to the presentation itself. So the presentation then, or what we are going to do is we are going to go into a bit of detail. It is prudent for you to know that when you look at the document, the actual bill, where it's underlined, it is the new proposal that has been made. Now, remember that we have already extensively consulted with both people in the public as well as government departments and so on. We have also taken this document in front of employer bodies as well as employee bodies. So as far as the bill is concerned and some of the issues raised, it is not a new thing. Where you see a square bracket, it means that that particular item will be removed, and it is being proposed that that particular issue be removed. So that is what I'd like you to keep at the back of your mind while we work through the document. The presentation itself, and even when I go to the document, we are not going to look at the cosmetic issues. The cosmetic issues are things that you can go through and you can get to know what's happening there. I'm going to cover the more detailed aspects of the actual bill itself and those areas where your comments would be appreciated. So don't be surprised when it comes to the Advisory Council that I skirt over that and a couple of the other things that relate to inspectors, the Chief Inspector, and so on and so on, where the Minister is allowed to make regulations. If you do have comments, you can make those comments on those areas. You're not restricted. I'm saying to you that I'm going to skip over it for the sake of this presentation because I can't imagine that that it's going to be relevant for me to discuss it here. You are still required, obviously, to read through the bill on your own, as indicated, so that you can make a broad input if you feel you'd like to. So the changes made to the Fourth OHS Act, as pointed out, the one that came out in early '94, there are some key changes that have been made. Probably one of the most, as I would call it, revolutionary, is the dual system that is going to be applied simultaneously at every inspection. So when an inspector is finished with the inspection, there are two processes that could follow, and we'll get to that later. And that is the big issue with regard to this particular bill as far as I'm concerned. Some things have changed and other things have remained the same. And those are the things that you'll see with neither bracket, and they're also not underlined necessarily. I've indicated that the bill has been in development for several years, and Cabinet had to give approval for that, for the bill to be published, which has happened. This is obviously a huge milestone. You will know that we are reviewing regulations, and I'd like you to keep in the back of your mind, for example, when we get to certain aspects, such as the health and safety reps, there is a component in the general administrative regulations that will either have to be updated or changed to some degree or removed, depending on what is required. The same with approved inspection authorities. You'll see a section in the Act that we're going to go through, but there will be a component that will be added to the general administrative regulations that you'll need to be cognizant of. So while the bill is coming out, there are some key aspects that will find its way to the general administrative regulations that will talk to the detail, which is not going to be necessarily in the bill itself. So the future then that we are looking at with regard to the bill, and also health and safety in the country, which you need to be aware of, and I talk to this frequently, is the informal sector, whatever that means, and also the formalization of the informal sector that is taking place currently with the ILO and various other business partners. What I found very interesting is reading up on what they now term the informalization, which is something that we'll go into on another occasion, not at this stage. But that is something interesting, where you have a formal job and you still do something on the side. That is now referred to as informalization in short. ARAs in the informal sector and how we are going to operate with regard to that, that is something that you can look forward to, that I'm working with my team on, because you cannot have an so-called informal sector. And by the way, some of the SMMEs will reside under the informal sector as well. Then you have women, children, and people with disabilities. That is quite important. This is an area that must receive attention in a greater way than it is currently. Then we have greater focus on occupational health issues, which you heard earlier, what came in as a result of the 1993 legislation. But just be mindful that how occupational health is not a new aspect to health and safety. It has been around for millennia, and it is something that we sometimes forget. Even when we look at the earlier 1900s, when with the introduction of Tyson and so on. So in the mining sector, there was already a move to deal with those issues. And on our side, it just didn't take the sort of complexion that it should have taken over the years. So that is an area that you'll see a lot more attention being given to. Even now, my people are working quite extensively in this on this aspect. Changes to policy, you'll see that trained inspectors who are specialists in their field, informed employers and employees and other stakeholders like yourselves, and then also tools to be created for the above. So we'll get on to the bill then. I'm going to move out of this particular document and then I'm going to get into the other one so that we can get into the presentation. So the document that you should have in front of you will have on its front page the fact that you need to submit information to myself, and you'll see that there's an email address. There's also a postbag address, and the deadline is 31 July 2021. Anything that's received after 31 July 2021 will not be considered, and it doesn't matter who you are or whatever role you play in industry. 2021 July 31 is your final date. After that, it will be placed aside and will not be considered. Please note that these rules are in place for a reason. So we're going to work through the document for the reason that I explained, and that reason is that you have the document in front of you, and we'll consider it. You can see this was referenced to by the CEO, so I'm not going to go onto that issue. We'll go immediately into the rest of the document. Now, the very important part, and I had the definitions as well in the presentation, but I'll go over them from this perspective. And I hope that you don't mind. This is the first time that I'm presenting on it, and it's quite I'm going to see how to take forward further presentations around this thing. Now, very important for any bill is what we refer to as the long title, and I'm quickly going to work through it. I'm not going to spend a lot of time on it, but it's important that you know that it's there. There's also something called a short title, and that's at the end of the document. So the purpose of this bill then is to amend the Occupational Health and Safety Act 1993 so as to delete, substitute, and insert certain definitions, to effect certain technical corrections, to make further provision in respect of the health and safety of persons at work and for the health and safety of persons in connection with the use of plant and machinery, to further regulate the protection of persons other than persons at work against hazards to the health and safety arising out of or in connection with the activity of persons at work. So this is pretty much the norm in the current Act and so on. And then also to further regulate the composition of an advisory council for occupational health and safety and to provide for matters connected therewith. So you get a fair idea what this bill is about, who it affects and impacts and so on. And just to remind you that it does cover people at home. And one of the big things that we're going to add in at some stage is the fact that domestic workers will be more fully looked at. So any domestic worker working at your home, and remember the broader definition of a domestic worker includes a gardener, etc., etc. And you can look at the broader definition around domestic worker, which means that if something happens with your domestic worker, you could find an inspector at your house coming to visit you with regard to what is happening with your domestic worker, because you have a workplace at your home and you can look at the definition around workplace. So we move into the definitions then, and I would have highlighted, and I'll make this available to the CEO to make it available online as well. Danger means anything which may cause injury, adverse health effects, or damage to persons or property. So the addition here is what you see. In addition to that, something that I missed, of course, is approved inspection authority means an accredited organization approved by the chief inspector as an inspection authority with respect to any particular service in terms of this act. So it could be one or more services, but you cannot get one approval and operate across the board. In other words, you cannot get it, for argument's sake, for asbestos, and now you're going to operate in the major hazard installation industry, or you're going to operate in the explosives industry. So you have specific AIAs operating in different industries. So that is, you'll now see that greater attention then is given to this whole issue around approved inspection authority, and it will come up later on as well. I'm not going to go through employer. Hazardous substance means a toxic, harmful, erosive, corrosive, irritant, or an asphyxiant substance or a mixture of such substances which creates a hazard to health. Incident, here just a bit of a change, means an incident, of course, has now changed to an occurrence. Now, listed workers has been something that has been around for quite a while, since the introduction of the 93 legislation, but has never been utilized. This is something similar to your sectoral determinations that you have in the BCA, but this is on the OHS side, and it's something that I have looked at now, something that we need to or will be using in the not too distant future moving forward. Listed work, and here you can see the change. Listed work means any work which poses a risk to health and safety, which requires specific precautionary measures to be implemented. So when you get to listed work, you're going to see a bit more detail, 11 and 12. and you'll see that we'll touch on that because there has been a change to it, and it's quite an improvement from where it was. However, to date, it has not been used, and you'll see, if you read the current act, you'll see that has never been put into play yet. Local authority, you can look at. Ministry, you can look at. Occupational disease means occupational diseases as defined in COIDA, the compensation for occupational injuries and diseases. So you'll see us aligning things as far as we can with the compensation side. Occupational health standards, something that needed to be introduced. Remember, the greater focus means a standard which, if applied for the purpose of this act, will promote the occupational health of employees or the health of any other person in terms of this act. You can see some interesting new things that are coming along. Occupational hygienist means a person who is registered with a body recognized by the chief inspector and who has the knowledge, training, skills, experience, and the required qualification in the field of occupational hygiene techniques to assess and evaluate levels of health and safety hazards that an employee is or may be exposed to at work. So here's something that a number of you will be interested in, and you can see whether or not this is in line with international standards, and if not, you will obviously advise us on that. Another good addition, which I thought was quite pertinent that we needed to add in, is permanent disablement. And you'll see that when there's injury statistics given, you'll see that permanent disablement is either featuring or not featuring. And in this particular instance, you are going to take note that it's now a feature that we are looking at, means a permanent disablement, as noted in COIDA, of course, as noted there. So this is an area that we don't talk about as often as we should, and there are quite a number of people that are becoming permanently or temporarily disabled that we are not taking note of. Risk means the probability that personal injury, illness, or the death of the employee or any other person or damage to property will occur, and we go into more detail on this particular aspect around risk. You'll recall that it was more like inferred in terms of the current act, and now we are going into specifics around this matter. Risk assessment means the process of evaluating the risks to an employee's health and safety from workplace hazards, and is a systematic assessment of all aspects of work that considers a complete hazard identification of all who may be affected by the hazard, how the person is affected, the analysis and evaluation of the risk, and the prioritization of those risks. So obviously, any definition, remember this always, any definition that is defined in an act or the regulation means it is not necessarily found in any dictionary. So you can go and look, and this definition most likely is not going to be found in a normal dictionary that from Oxford or one of those organizations. So what I'm saying to you is risk assessment is going to feature quite in a very big way, and it has been a major issue, but we have not had a legislation giving us clear guidance and so on on the matter, and now we do find that it's doing so. Risk management means the identification and mitigation of risks by the application of appropriate control measures. And these things are going to be looked at obviously in detail by the inspectors, and they'll be trained up to ensure that they're able to question you and to ensure that these things are in fact adequate when applied at the workplace. Now, the next big introduction, of course, after the risk aspect is a safety management system, or health and safety management system, if you like, means a coordinated, comprehensive set of interrelated or interacting elements to establish occupational health and safety policy and objectives in order to optimally manage health and safety. So major change, and I think it's a good one. However, you may feel that you would have defined it differently, or you'd like to input into this area, which of course we would appreciate. Safety standard, as opposed to what we saw earlier on, a health standard means any standard which, if applied for the purpose of this act, will promote the safety of employees or any other person in terms of this act. And you'll realize that up to now, safety has been a major issue in terms of creating the structures to operate in a self-regulatory way for employers, employees, and the general industry, including the members of Saiosh, of course, who would rely on the experts in the different areas to assist them. So we are moving closer to what we would consider that obviously that top point of health and safety, where we can feel that occupational health is equal to occupational safety in terms of the attention that it's receiving. SANAS, you'll recall that when the 93 Act came out, SANAS was nowhere to be seen, and obviously they were building up towards it. And subsequent to the 93 legislation, SANAS was established and is fully fledged and running, and they are operating under a DTI, just as SABS and so on is. So SANAS now forms an important structure that we utilize, and they do the accreditation before we do the approval as far as the framework for health and safety in South Africa is concerned. And we are going to continue working with them going forward. Now, self-employed has always been there. Section 9 is pretty clear on this issue, but there's a definition here. Means an individual who earns income through conducting profitable operations from a trade or business which that individual operates directly. And maybe you don't like that word profitable there. What if it's not profitable? How do you take, how will this whole thing affect you then, and so on and so on. So you can see it could be that you are going to indicate to us that you're not profitable, so that we don't look at you if you are self-employed. So this is something that we might have to look at and reconsider. Remember, this thing only will become final once it goes through the president at a later stage. Now, something that you need to look at, standard year, the addition in standard adds the following: provided that anything that is required to conform to this act shall first be subjected to the required tests by SANAS, accredited to do such tests to ensure conformance to a particular standard. So this is quite important. SABS, you'll see later on when we talk to standards, they have an additional role to play, and you'll see that SANAS also has a role. They also look at laboratory issues and so on, and you can obviously go and do your own research on it if you don't know much about them to find out what exactly do they do. But here's an addition now to what we are requiring them to do in relation to standards and so on within South Africa. User then has a small addition to it. You'll remember that there is already a definition for users in the current act, but in this one, it removes in relation to plant and machinery and it puts in means a person who uses the premises, articles, substances, plant or machinery for his or her own benefit, or has the exclusive right of control over the use of the premises, articles, substances, plant or machinery. So the premises, articles, substances is the addition in this under user. And then another one that over time has been something that is not in the current act, but you do get questions around it, is volunteer. Means a person who willingly provides a service to an institution or organization, including a government body or organization or a non-governmental organization, without being remunerated for services rendered. So there you have a definition of volunteer, and you can obviously decide whether or not it is sufficient, because some of you might have wider experiences and you'd like to enrich this particular definition. And then we get to the end of the definitions, if you like, and we go into the bill itself. And sorry, before we move off the definitions, you'll remember that there's an addition there. There's a number 2 after the number 1, dealing with clearly with the definitions. There's a number 2 and 3. Now, mines or the minerals guys do have their own act and so on. So in terms of the mining side, we don't get involved there. However, sometimes we have to speak to one another in order to determine where the border is, in fact, between the two areas of responsibility and whatever that may be. So you could have mining, you could have an explosives workplace on ground level and mining taking place under the explosives workplace. Can that happen? Should it be allowed? And so on and so on. What is to take place there? And those are issues that we need to sort out. But there could be various other aspects and experience over time with regard to that has told us that there could be areas of borderline issues. Of course, the civil aviation side, they have their own act. You can have a look at it, and permits are being issued in order for various organizations to operate under this act. So there is a clear line again as to where we get involved and where we don't get involved, and the same for the nuclear side. We, for example, can go into Kuwait power station, but our role there is going to be non-nuclear related as opposed to the other work that we do, like pressure equipment and so on. On the MHI side, you know that that's one of the exclusions in relation to the MHI. Now, when it talks to load line shipping and so on, finally, I can say to you that the load line ship aspect is something that we don't look at anymore. Up until now, even, and remember that SAMSA, South African Maritime Safety Authority, was also not in place at the time of 1993. So where there's the inclusion currently of us still going out and looking at those aspects, that particular proclamation did not take place. And what you have now is you have a Maritime Safety Authority in place, but this legislation has never been withdrawn, and therefore it remains active despite the other authority being in place. We, however, choose not to get involved there because they have a clear mandate in terms of what they have to do and how they do it and all that kind of stuff. So this area will definitely be amended, and we'll definitely remove the part that refers to load line shipping and so on. I said to you early on, we're not going to get involved in the council. There is one aspect I'm going to touch on with regard to the council issue. Under Section 6, Section 6 talks about the establishment of a technical committee of council currently. And what we are adding is and sectoral advisory forums. Now, currently you have a diving council and you have an explosives council, and wherever you're having councils, those councils are going to be referred to as sectoral advisory forums, not to be confused with the advisory council. And the advisory council that was involved with this bill indicated that they want to give it another name. So you have technical committees that can be established that will do work on behalf of the advisory council, and that will be established, and so on and so on. The sectoral advisory forums that will be established have a different function, and let me show you what that function is in writing so that you can have a look for yourself. So a sectoral advisory forum then may be established by the Chief Inspector to advise the Chief Inspector on matters relating to any regulation made under Section 43, such as your diving council, which will undergo a name change, and your explosives council, which will undergo a name change. And let me not forget, before I get berated, your construction regulatory, your construction regulations also has a forum, and that will fall under the name, this particular name. And that is to advise the Chief Inspector on day-to-day matters with regard to different fora, the different fora that are established. Now, the time frame for these forums and so on, there's a short time frame, and I don't want people sitting for years and years on the same forums for obvious reasons. No new blood, no new ideas, and so on and so on. So you'll see that these forums do have a restriction. However, may I add at the same time that when it comes to the advisory council that advises the minister on legislation, let me just add that the minister obviously can reserve the right to reappoint someone in a particular area. I will make recommendations to the minister, of course, around any appointments that are made, and that will go through, but it's still up to the minister to decide on who and what and why and when and whatever. So this is just to let you know, when you see something like the construction forum, this is where it's going to fit in, and so to the explosives and diving councils, amongst others. Health and safety management system, we went over the definition earlier, and here you can see where it comes in under Section 7. It says the Chief Inspector may direct an employer or group of employers in writing to develop and implement a health and safety management system. A directive under subsection 1 shall be accompanied by guidelines concerning the contents of the health and safety management system concerned. So you're not going to be handing in a document that has, in other words, 10 of you handing 10 different documents, and they all are so different that one cannot make head or tail what's happening. So you're going to be given proper guidance in regard to this. When this thing is published, you'll have that guidance as well. So amendment to Section 8 then of the Act, and you can see the areas that are being added: conducting a workplace risk assessment, and thereafter developing and implementing a risk management plan in writing in respect of every risk identified, ensuring that the workplace specific risk assessment is conducted by personal persons who are competent to pronounce on all the risks associated with that workplace. And then C, ensuring that workplace specific risk management plan is in place and is available at the workplace when requested by an inspector. So you've been given clear input in terms of what you're going to be doing. And don't forget the definition that we've also gone through. And then let's just finish us Ensuring that no work is undertaken unless the control measures contained in the risk management plan are complied with. Now, look very carefully at this and ensure that you comply with these issues, because if they're not complied with, you're going to be in contravention. And when we go over the contravention issues later on, you're going to see how critical it becomes. Again, this is something that I referred to as one of those superficial changes. You can go through that on your own, of course. All of you can read as well. Mine is just to tie up the gaps that you might have in relation to when you read through it. So the last part then also ensuring communication of the relevant components of the risk management plan to every employee. Now you're going to see, you remember under section 13, it says duty to inform, and we're going to go over that again later on. You're going to see how important it is. So in this particular issue, we're saying ensuring communication of the relevant components of the risk management plan does take place, and every employee knows what is happening. It's not, look, you've spent a lot of money to put it together, put it in place, and now you go and shelve it. Not cool. And also, how does it influence anything else at your workplace? And one of the things that we found during the COVID period, of course, is the fact that a lot of you do not have risk, have not factored in risk issues in your risk management plan if you had one. And when you didn't have one, the reasons for you not having one is mind-blowing. And when you have a risk management plan and things change, your risks could change, and therefore your whole everything to do with risk needs to be updated. When COVID was introduced, we had to tell you to change things and include it in your risk issues. A lot of companies didn't, and even today we are still serving notices on that, which for me is a bit unacceptable. It's one of the fundamental aspects of the work that we do. When I say we, you and I. So section 9, you know what section 9 is. It's the aspect that talks to self-employment and all that kind of stuff. How does it change? Every employee shall conduct an undertaking in such a manner as to ensure. And take note, this particular bill removes, as far as reasonably practicable, out of a number of sections, which means you will not be able to rely on the 4 criteria that makes up your reasonably practicable issue. In other words, here there's no debate, you are going to do it. There's no debate. There's no, I don't have enough money, I don't have enough knowledge, whatever the case is. Here it says to you, you are going to do the following. You will ensure that the following is done. Now remember the square brackets I pointed out to you. The square brackets means that it is removed from the Act. Now, to ensure what? That the risk posed by identified hazards to persons other than those in the direct employ of the organization who may be directly affected by the organization's activities are not thereby exposed to hazards to the health and safety, and the risk is managed in line with the risk management plan. Please, this is so important. The number of accidents also that have taken place involving people who are not even employed by the company or are people who happen to be members of the public is mind-blowing. And they have happened, fatalities and so on and so on. And I can go through examples, but we don't have that kind of time at our disposal today. So be mindful that there is a change here in relation to other people other than your employees. Every employee shall conduct an undertaking in such a manner to ensure that the risk posed by identified hazards to persons, not employees, not other workers, to persons other than those in the direct employ of the organization who may be directly affected by the organization's activities. Now, you might think that it would maybe only apply to MHI, those of you that might be new to the health and safety field, and it doesn't. It does not. It applies across the board, and one of the culprits in this area could be a construction where construction is taking place, and the chances of someone other than employees getting injured or dying is far greater in that regard. So be aware then that that is covered. And then also, you remember we touched early on the definition of a self-employed person. Every self-employed person shall conduct an undertaking in such a manner as to ensure, and take note, there's a square bracket that removes certain things, that the risks posed by identified hazards to that self-employed person and other persons who may be directly affected by the activities or the work performed on that premises are managed in line with a specific risk management plan as contemplated. A lot of emphasis is being placed on the whole issue around risk management and the risk management plan and so on and so on. So heads up to you on this one. We are obviously going to clean out workplaces. And when I say clean out, it's going to be the first thing we're going to request. And we're going to deal harshly with employers when you look later on at how this thing is going to pan out when there's a contravention. You remember what they say, that forewarned is forearmed. And this is what the session is about, making sure that you are also forewarned. Any person who designs, manufactures, imports, sells, leases, or supplies any article for use at work shall ensure that. Now remember, section 10 has some of these issues already in it, and take note, as far as reasonably practicable falls out. And also some of the old dogs amongst us, such as Garth Hunter, for example, tell you that the old foot stewards thing used to apply during these years. It doesn't apply anymore. So foot stewards does not apply unless you're also compliant with the other pieces of legislation that are relevant to you selling things to other people. And this act is no different. This act is now up to date with regard to issues like that. And then the area I'd like to quickly bring to your attention, the article is accompanied by the instructions which include precautionary measures to be adhered to. Take note of that, please. An incident I did many years ago, one of the things that they brought out was a brochure. And this became a legal argument, and not only a legal argument, but it became a noose around certain people's necks because they couldn't explain away the purpose of a brochure and how critical the brochure was in terms of the product that was being utilized at that particular time. So any information that you provide, make sure that your company has in fact properly and adequately signed off on that information. Any person who imports, sells, or supplies any substance for use at work. Now, at this stage, I'm also going to tell you that as we move into this particular matter, here we get it, a person who manufactures, imports, sells, or supplies a substance for use at work shall ensure that the substance is classified, labeled, and packaged in the prescribed manner. Now, for those of you that recognize it, it is definitely a globally harmonized system issue. You will also notice that it comes out of the the hazardous chemical agents, or the old hazardous chemical substances regulations that have just been revised, which incorporates the GHS, but this also does so in the way that it's written. So be aware of that. This is a GHS matter that they've also incorporated there. So we're going to go to the next. You can see I'm skipping some of the more superficial issues for you to go through. So section 12, then early on I spoke to you about listed work, and listed work then picks up here under section 12. Let's go through it. An employer shall conduct a risk assessment. Take note, it comes under, and it's a new issue. Shall conduct a risk assessment in relation to such listed work and develop and implement a risk management plan in respect of the risks identified for that work. A risk assessment then conducted for that workplace shall be conducted by a person or persons who are competent to pronounce on all the risks associated with that work. And where the risk is complex in nature, a risk assessment shall be conducted by specialists who are competent to pronounce on all the risks associated with that particular work. Now, take note of that. Shall be conducted by specialists with an S, where the work is complex in nature. So if you're looking at several different areas requiring several different experts, such as in hazard analysis, possibly, then you're going to have them involved. And it's going to be critical that you list those people after you have finished the work that you have done and add it to your risk management plan and so on and so on, so that it can be seen that it wasn't a one-person show in relation to producing the documents and so on. The employer shall ensure that a workplace-specific risk management plan is in place and is available at the workplace when requested by an inspector. Now here, please, it doesn't matter if it is with your consultant. If it's not at the workplace, it's not available for an inspector, which makes it a contravention. And when you look how serious the contravention issues are moving, in a couple of minutes we'll see it, then you'll see why when it says you must have it at the workplace, have it at the workplace. It doesn't say have it with your consultant, have it with your head office, have it with your CEO, whatever the case is. When an inspector is there and they've notified you up front, they expect to see it. An employer may not permit any listed work to be undertaken unless the control measures contained in the risk management plan are complied with. Now we go to section 13, which deals with the issue I spoke to you earlier on about the communication aspect. And you'll remember that duty to inform, which is section 13, touches on the following. We take out reasonably practicable, as you've seen in several different places. It says, ensure that the employee, that every employee is conversant. Ensure that every employee is conversant with the risks to his or her health and safety attached to, and then it goes on and you can read that. Now, it is the employee who is going to be exposed at the end of the day, and they need to know what they are going to be exposed to. You bring on a new machine, you bring on an old machine that's been modified from somewhere else, and so on and so on, and you expect 5 minutes training is going to solve your problem, and it doesn't. Here it says that, ensure that. Now, how do you go about ensuring someone is conversant? And here you're going to have to go and look up what the word conversant means. I'm not going to tell you what it means. There's homework for you, Mr. Nokia. There's homework for your members. So that you understand when we talk conversancy, conversancy is undoubtedly that the person walks away with clear knowledge and can demonstrate that they understand what you have said, in short. And you can go look it up too. Again, there are small changes in between, and some of them are gender issues that you can go through on your own. Now, Section 15, if you like, this is the old Section 16 that we have currently. It says a chief executive officer shall, and take note, it again removes, so there's a clear duty imposed on the employer here, shall ensure that the duties of his or her employer as contemplated in this act. So everything in this act where it says employer means that the CEO has to carry out those duties. And it says here that all those duties must be properly discharged by the CEO, unless, of course, and we'll have a look at what the unless is. Now, here we've got an addition of 1A. The chief executive officer shall develop, implement, and continuously review the health and safety management system as the employer may be directed in terms of Section 7.1. Then we go on to 2, without derogating from his or her responsibility or liability, a chief executive officer may, in writing, now it changes it, remember it says currently assign. Now it's been changed to in writing, delegate any duty contemplated in the said subsections to any person under his or her control, which person shall act subject to the control and direction of the chief executive officer in the interest of occupational health and safety. Now, let's first cover these issues and we'll come back to it. 2A, a person so delegated in terms of subsection 2 may not further delegate the duty to any other person. The age-old question that we get asked, and let me clear up something here now. And I understand that some people have the view, but I'm telling you what the view is of the Department of Employment and Labour and the legislator on the matter. The CEO here is not an OHS CEO. It is the CEO of a company. As you know, CEO. That is what is being referred to. You're not a OHS CEO, any such funny business. And let's be very clear on that one, please. So, no further delegation. It's an old issue that has not been clear for the many years that this act has been in place. And then lastly, an addition here, it shall not relieve an employer of any responsibility, accountability, or liability under this act. So when you're looking at section 16.2, and we'll go back to that quickly, when the CEO cannot perform all his or her functions in terms of this act and its regulations, when it cannot be done, the CEO is then going to delegate some of the functions to someone that is deemed to be under their direct control, and so on and so on. I'd like to draw the issue to it. Any functions that are given must be clearly stated. If it's to sign health and safety appointments, if it's to manage any particular issue that is required by the Health and Safety Act that the CEO is required to do on behalf of the employer, then that must be in writing. Do not state emphatically that it is all duties as listed by the Occupational Health and Safety Act. You will be wrong in doing that. So I'd like to leave that as having been discussed, and we'll obviously make sure that in a guide note we further elaborate on the matter as far as it is necessary, and also based on some of the comments that you'll send. So this could change. Some of the things will remain as we have it, but you might want to add something in as you feel that Section 16, even what we have proposed, is deemed to be inadequate as far as you're concerned. You might be in a big organization and feel that this doesn't suit your organization. What is your proposal in regard to this? So this is on the health and safety reps, and just so that you have it, this is on Section 17. You can see that it deals with a number of employees. And this is quite an important section, Section 17. And you'll also know that there's currently something in the general administrative regulations that is more or less the same. It is not the exact same duplication, what you see here and what you see in the general administrative regulations. You will see that they are not exactly the same. However, this that we have in the Act will take precedence over what is in the current Act. This bill will take precedence over what's in the current Act and will amend the general administrative regulations accordingly. So the GAR is not going to stay the same once this thing is published. But you can, of course, go into it. One of the important things here, of course, take note of the square bracket that is there. Take note of it. And I'm going to quickly read that subsection 2. An employer and the representatives of his or employees recognized by such employer, or where there are no such reps, the employee shall consult in good faith regarding the arrangements and procedures for the nomination or election period of office and the subsequent designation of health and safety reps in terms of subsection 1, provided that if such consultation fails, the matter shall be referred for arbitration to the Conciliation for Mediation and Arbitration, in other words, the CCMA. And I need you to be very clear on the change. Square bracket falls away. Now, something that you're going to see taking place throughout the legislation, and remember some of these things fall into a section in the current Act. You'll see that you're going to be able to get information from the Department of Employment and Labour, and this information you're going to expect to get within a certain time frame. And this is what you see here. And you'll see it in other places as well, and I'll bring your attention to it. The Department of Labour, Employment and Labour is going to be required to give you information. You'll see that throughout, and the time frame that it is required to be given to you will also be stipulated. Okay, so a health and safety, you'll remember that there are duties for a health and safety representative. There's duties for a health and safety committee. Currently it's Section 18 and Section 20, and those duties are quite important with regard to the parties. Now, the current requirement is that a health and safety rep doesn't need to perform the duties as such. There's a sort of a requirement placed on the employer to make sure that the duties of the health and safety rep gets done, but it's not that the health and safety rep must do things currently. However, the bill itself, as it now stands, will require the health and safety rep to do things. It will no longer be an option when this Act is published. The health and safety rep must now do it, and so you'll find that the burden on the employer is lifted slightly, and the health and safety reps are now required to do whatever the legislation states. So health and safety representative shall, in respect of the workplace or section of workplace for which he or she has been designated, be entitled to visit the site of an incident or when an employee was directed to leave the workplace. That's another big change that you're going to see us talk to in a moment. There's a part where an employee can leave the workplace. We'll see what that is about. When an employee was directed to leave the workplace. Attend regular meetings with employees at the workplace, with the employees at the workplace to address health and safety in the workplace, provide feedback, information to the employees they represent, discuss reports by the health and safety rep on the performance of their functions, and receive mandates from employees to be presented when attending the health and safety committee meetings. So employees are going to have to give time within working hours to health and safety reps to be able to do the functions that are being discussed. It's not a case of you'll do it in your own time or do it after work, do it during your lunch time, whatever the case is. Where this is required to be done, the time must be given to the health and safety rep to do that. Addition, then, attend a special meeting with employees they represent after an incident in order to provide information on the incident, inform employees regarding arrangements for undertaking the investigation of the incident, and gather information from employees relevant to the incident. So health and safety reps that you have are obviously going to have to be in a position to do these things. It's not a case of they're appointed and someone else is going to do it. Here it's clear they are a resource to the employer, but obviously they are interacting with employees as well, and they have to make sure that things are happening on the ground. And then whatever these activities are that's happening, they're obviously going to find, it will find its way to the health and safety committees that you know should be established under certain conditions, of course. So we move on then with the health and safety reps, of course, request and have access to inspect any documents which you know they can, which the employee is required to keep in terms of this act, and where the document is not made available within 14 days of the inspection, the information may be requested for the chief inspector, subject to section 36. Now, of course, this is something here that I'm not crazy about. Obviously, it means that the inspectors at a lower level will have to get involved. There is supposed to be a self-regulation thing at play between employers and employees. Why would the employer play hardball with an employee when they should be working together in the interest of health and safety regarding the workers? So this will be taken quite seriously where we get involved, of course. Report on instances of non-compliance with this act to the employer or the health and safety committee. Now, this becomes quite crucial. If something is reported to the health and safety committee, like the chairperson, and the chairperson of the health and safety committee interacts with the employer or a person appointed by the employer, and nobody does anything, how serious should we take that when we expect employers and employees to be working together? So section 19, then a workplace with one or more health and safety reps designated shall establish, as you know is the case, one or more health and safety committees. You know that that is currently required. Health and safety committee shall consist of the number of members in accordance with a collective agreement. And this is something that I wanted to put forward to you. Be aware of where this appears, this issue around collective agreements, when it comes to health and safety. In accordance with a collective agreement where one exists, or as may be determined by the employer and the employees, or the employer representative for the efficient and effective operation of the health and safety management system. Excuse me quickly. Now, one of the challenges that we found, having gone through the COVID year, is the effectiveness and efficient running of not only the Health and Safety Committee, but of the health and safety reps in what they are required currently to do, and what the Health and Safety Committee is required currently to do, both in a public sphere as well as a private sphere, was a disaster. My question is, why does it need to be a disaster? Why do we have to wait for a pandemic for something like this to happen? And let me also further shock you by saying, maybe you won't be shocked, by saying to you that throughout the COVID period, if we exceeded 60% compliance, I most likely would have thrown a party, and I would have invited Saiosh to it as well, of course. But jokes aside, this is absolutely horrific that in a pandemic, we started at around about 60% and below possibly. And throughout the year, 12 months of the year, we didn't move very far from that, either upwards or downwards. And certain sectors, and I can't stop talking about the construction sector, that was absolutely phenomenal in terms of its achievement, whereas some of the others were a total disaster. But construction, I think iron and steel, the financial services sector, the chemical sector, those are some of the sectors that did relatively well. The rest, in my opinion, were a disaster because they never ever went past 50% in some cases, or even 60% in some cases. So your effective and efficient running of these committees in order to ensure that self-regulation is taking place. If you tell me, and I have a look at your minutes, and I can see that your health and safety committee is a disaster, your health and safety reps are a disaster, and so on and so on. Self-regulation doesn't exist. Where are we going to in the new Act, Health and Safety Act, or the current bill when it comes up, when the penalty system is a lot more onerous than it currently is? The persons nominated by an employer on a health and safety committee shall be designated in writing by the employer for such period as may be determined by that employer, may be determined, while the health and safety reps shall be members of the committee for the period of their designation in accordance with their collective agreement, only where one exists, or as shall be determined between employer and employees. And here's a change that must be noted. A health and safety committee shall hold meetings as often as may be necessary, but at least once every 2 months. And currently it says once every 3 months. So this will change. May make recommendations to the employer where the recommendations fail to resolve the matter to an inspector regarding any matter affecting the health and safety of persons at the workplace or any section thereof for which such committee has been established, or to the representative trade union, in which event the inspector shall attend to the matter in terms of section 29. The representative trade union may declare dispute in accordance with a collective agreement where one exists. So you can see there are some not so subtle changes and could impact on the operation of an employer's business when it comes to health and safety now, when considering these aspects. shall identify all occupational health and safety regulations that are relevant to the workplace activities or substances, shall ensure that all relevant information, training, assessment, monitoring and recording provisions are in place, shall make recommendations for inclusion in a workplace, the health and safety management system and safe work procedures. Shall review the training and information provided to employees regarding any hazardous substances or condition as spelled out in the regulations. Shall perform such other functions as may be prescribed or agreed to in a collective agreement where such agreement exists. You can see I've tried to just take out the relevant issues so that you have a fair idea of what's happening. Now, when it comes to section 24, and you know that section 24 deals with incidents currently, we'll just quickly just familiarize you with it. So you'll see that there's a slight change in A and in B. Let's see quickly, you'll recognize their major incident occurred, and you'll recognize also those of you who are involved in MHIs, it refers to a major incident occurred, and you would have had major incidents come up as a major hazard installation in that regulations. So here we've changed it. In the course of an employee's employment, an incident occurred which resulted in personal injury, illness, or death of the employee. The health or safety of any person was endangered, and where a hazardous substance or biological agent was spilled or released. Take note of the change here, please. Take note where it refers to this. When I spoke of the change of domestic workers earlier, you'll recognize here where it talks to the provisions of subsection 1 and 2 shall not apply in respect of a traffic incident on a public road and an incident occurring in a private household, provided that the householder forthwith reports the incident to the South African police. Now that one will change, of course, and we will include domestic workers, which means that the employer of the domestic worker will be required to report serious incidents, which could include, unfortunately, death at your home, which would be a workplace, which has happened in the past, of course, with regard to electrical installations, amongst other things. Now, an important issue here that I've made an X against: the employer, user, or self-employed person shall provide the department. Now, there needs to be information. We get questions from everyone, all and sundry, and we are also linking with the compensation fund to get information. However, we need to make sure that this information is signed off by yourself, of course. The employer, user, or self-employed person shall provide the department with a copy of incident statistics annually on the 1st of March of each year. The incident statistics referred to in paragraph A shall be provided in the prescribed format, which means that we have to provide you with a format. The incident statistics shall include statistics for contractors that occurred while on the employer's premises, provided that the contractors are required to provide incident statistics to the department as well. So it will be a good cross-reference checking for us in relation to this. And of course, at some stage, we'd like to make this an online issue going forward. Once this thing is published, we'll look at trying to make it so that you can do it online and we can draw it off in that way. Now, victimization forbidden, you'll remember that currently victimization and the way it's tabled in the current act is one huge, I don't know what to call it, glob of letters. And if you're the type that doesn't get bored very fast, you could read through it. Otherwise, most people will lose interest a third or a quarter even of the way through and then give up on it. This particular bill has broken it up and has only included the very relevant portions that we would like information on. So let's quickly go through it. An employer may not discriminate against an employee for exercising a right conferred in terms of this act. So we are saying that where an employee reports something in terms of this act, an employer cannot, or an employer representative cannot go ahead and charge someone like that or victimize them, excuse me. We're saying that such, let's go on. No person shall do or threaten to do anything that requires an employee to exercise a right conferred in terms of this act, prevents an employee from exercising a right, prejudices an employee because of past or present, failure or refusal to do anything that an employee may not lawfully permit or require an employee to do. Disclosure of information that the employee is lawfully entitled or required to give to another person, could be at an inquiry or something like that, or whatever else. Exercise of a right conferred in terms of this act. No employee shall favor or promise to favor an employee in exchange for the employee not to exercise a right conferred in terms of this act. So that is victimization. And you can see that it's been whittled down substantially in terms of where it was to what we have currently. Section 28, the minister may designate, and this is quite an important thing, may designate permanently or temporarily any person as an inspector to perform, subject to the control and directions of the chief inspector, any or all of the functions assigned to an inspector by this act. Now, when this particular act bill was written, the chief inspector was at a certain level. Now, what you have now, we have above the chief inspector, you have an inspector general, and the chief inspector reports to the inspector general with regard to certain aspects. So over here, this will be changed to an inspector general who has the control and so on over the inspectors. Now, an important part that I would like to bring to your attention, an inspector today is given a card. So any inspector that you know of who comes to your premises and says, I'm an inspector, that inspector must be able to produce you an inspector's card, which is signed off by the current inspector general, and it allows them to operate as an inspector. And just out of interest, I don't know if you can see that. That is what the card more or less looks like. And these cards could be updated or it could change, but we will obviously inform you accordingly as well. So the inspector then is required to have a card that is signed by someone who could be delegated to the minister directly, and in this case, the inspector general will sign off on the card. The card shall include the name, a unique number, an identity number of the person concerned, a photo of the bearer, and the designation of that person. So any person that comes to your place and says, I'm an inspector, you can say, Give me the name of the provincial chief inspector. Don't say the national chief inspector for health and safety, which is me. Say the provincial chief inspector or the health and safety specialist for that province. Each province has one each of those designated people. So you can phone them up, and their details are online on the Department of Employment and Labour's website, and you can clarify the matter. However, they must have this. If they do not have it, do not feel guilty or anything like that. Tell them they're more than welcome to come back if they have the information. Currently, even right now, they should have the card that I've just shown you on them. If they say they've lost it, they must get another one. They should have reported it if it was lost, and so on and so on. So we've just indicated, rather than say certificate, you can say you can see it, we withdrawn the certificate. They must have a card, and we have given them all cards in that regard. So in terms of section 29 then, an inspector may, for the purpose of this act, without any previous notice, at all reasonable times, enter the premises which is occupied or used by an employer on or in which an employee performs any work, including your domestic work, any work or any plant or machinery is used, or which the inspector suspects to be such a premises. And I've indicated this now several times to you. But there you see it, and you're more than welcome to make an addition there. I'm not averse to the issue of the rights of home of people and their homes, and the right to access in terms of the Constitution and all that. I'm totally aware of the issues around that. I'm also saying to you at the same time that where there is now a workplace, the inspector would be able to enter such workplace, and obviously the inspector will make the necessary arrangements with you up front in order to do so. Issue an administrative fine. So here we see administrative fines in terms of section 37A as indicated by schedule 2, which we'll get to. When so required, take photographs and make audiovisual recordings of any workplace, anything or any person within the workplace which may be relevant to an inspection or an investigation being conducted by the inspector. An interpreter, a member of the South African Police Services, or any other assistant may, when required by an inspector, accompany the inspector to perform his or her functions under this act. And this is the person that's different to a person that is employed either permanently or temporarily as an inspector, as noted a couple of lines up. This could be somebody that's accompanying an inspector. Very important, this one for you: when an inspector removes or seizes any article, substance, plant, machinery, book, record, or other document as contemplated in those subsections, the inspector shall issue a receipt to the owner or person in control thereof. To the owner or person in control thereof. Now, already there's something there with regard to a receipt. There is something. So it's not as if there's nothing there. However, this is an addition, provided that the inspector shall, as soon as reasonably practicable or at the conclusion of any proceedings, which proceedings include the investigation or an inquiry or something like that, in terms of this act, return whatever he or she has seized, unless the employer says differently, in which case it will be in writing. Subject to section 40, when an inspector has undertaken an inspection, the inspector shall provide a copy of the inspection report or copies of any notice and correspondence that was issued during the inspection term. Take note of this. I referred to this aspect early on, and now you are going to have the required tool that will give you access to information without you applying for that information. To the employer, the health and safety rep, and the representative trade union for that workplace. And in the case of a construction site, the construction client, principal contractor, or any other contractor on site, if applicable, and all persons as noted in paragraph A, of course. So that's good news to some of you, of course. An inspector shall, no longer may, an inspector shall investigate the circumstances of any incident which has occurred at or originated from a workplace or in connection with the use of plant or machinery which has resulted, in the opinion of the inspector, could have resulted in the injury, illness, or death of a person, not an employee necessarily. It could be any person. So there you have it, an inspector shall and not may. And you can see the part that's been removed with reference to section 32. For the purpose of an investigation referred to in subsection 1, an inspector may subpoena any person to appear before the inspector concerned on a day and at a place specified in the subpoena and give evidence or to produce any book, document, or item which in the opinion of the inspector has a bearing on the subject of the investigation. You can see the addition to this part. It's not necessarily there now. It is there for section 32. However, if the inspector makes a request, we are just making it more explicit as opposed to when inspectors requesting information now and can do an investigation. We are just breaking it up further so that it's clear what is happening and what we are trying to do. I'm just skipping to the relevant parts quickly. Okay, so this is all there at the moment anyway, in some form or the other, so I'm not going to go through it. If you do read through it, you'll find that some of the stuff is there. Now, when we come to the appeal side, those of you that have done appeals, those of you that know about the appeals and so on, there is a particular process that you have to follow. And you have to motivate and so on. And sometimes we get this in a form of an email in a rather informal way. And this is a formal process that is being followed. And here it's about the evidence that you have as an employer and the evidence that you're going to submit in order to back you with regard to what is happening. So let's quickly do this. A person aggrieved by a decision. Now, let's be very clear. A person is any person. Aggrieved by a decision. What is that decision? And what you need to look at is whether or not it was a decision as you would or maybe would want to define the decision that an inspector is taking. For example, let me give you a simple thing. An inspector drafts an incident report, an incident investigation report in terms of section 31. So the inspector does an investigation and the inspector may possibly make recommendations. May make recommendations because the NPA are the ones that make the final decisions on the issue. In the case of the report, where the inspector provides all the evidence is provided, is the inspector making a decision in that instance, and can you therefore appeal where the inspector has forwarded a report to the NPA for a decision to be made. So while I've sort of worded it in a way that would make it a bit awkward for you, you need to decide, and this is the crux of the discussion here, is it a decision? Because sometimes you are going to send through an appeal and there was no decision made by anyone. Now, let's say there was a decision that was made and a notice was served or a directive was given under a provision of the Act, and you appeal against that. And you can have a look here, there's an exclusion that's been noted. Take note of the square brackets that exist there. And here's a new addition to the thing. Now you decide, after you've now made the decision that you're going to appeal, and you now send that appeal through to the Chief Inspector, which is currently myself, what is going to happen? And everything is described, including time frames and so on. So what is happening is the 14 days, 60 days that you're currently given, let's say you make a decision to appeal, you are then given 60 days, a 60-day time frame. So once that 60-day time frame kicks in, you are going to expect a response from the Chief Inspector's office. However, in terms of the new bill, the time frames are all changing in relation to that. So after it goes to the Chief Inspector, and you can see how this goes, you can see there clearly stating or setting out clearly the grounds on which the appeal is based, as I've stated. Chief Inspector gets and makes a decision. And if you look at A, it says confirm, set aside, or vary the decision. Once that is done, after the Chief Inspector has also consulted the inspector on the matter, what the inspector has done, the Chief Inspector gives you the decision. If you're unhappy with the decision of the Chief Inspector, currently you're going to go to the High Court in order to lay your case at the High Court with regard to whether or not you agree with the Chief Inspector. You don't need to agree with the Chief Inspector. If you disagree, go to the High Court. However, what some people are doing is they are arguing the matter at all different levels, escalating the thing as if after the Chief Inspector's decision, you are allowed to do that. The Act is clear. Once the Chief Inspector's made a decision, he's not necessarily going to change that decision once that decision is made. And he cannot be given an instruction by anyone to change the decision. Imagine I get called to the High Court and I say there, oh, the state president told me to change it, or I phoned a friend and my friend told me to change it. No, it cannot be. Once the decision is made, the only other organization that can change my decision is the High Court. A person aggrieved by a decision taken by a Chief Inspector, this is what the bill says, under Section 35, or in the exercise of any power under this Act, may apply for such decision to be reviewed by the High Court. The High Court may confirm, set aside, or vary the decision or substitute the decision with any other decision. A person who wishes to review a decision referred to in subsection 1 shall, within 60 days after the delivery of the Chief Inspector's decision, lodge the application with the Registrar of the High Court in accordance with the rules of the High Court. So there's clearly stated how this whole thing can play itself out. And you cannot follow your own set of rules. This is it. In the current Act, the same thing. Appeal does not suspend the decision of the Chief Inspector. An appeal or review under Section 35(1)A, 35(A)(1) in connection with a prohibition imposed under Section 31A, B, or C. There are 3 categories for a prohibition notice under which a prohibition notice can be served. Does not suspend the operation of such prohibition. So the prohibition stays in place even if there's an appeal process that takes place. And that must be clearly understood. The prohibition notice does not fall away during an appeal. What does happen is, what we are doing at the moment currently is, for a contravention and improvement notice, we do hold it back until the decision of the chief inspector is made, or if it goes to the High Court, if it goes to court, then the notice will obviously hold back until such decision is made. If everyone upholds it, in other words, you go to the chief inspector, he upholds it, you go to the High Court, they uphold it, at that stage, the notice kicks back in again. We're getting to the key issue in a moment. Despite the High Court, despite subsection 1, the High Court may suspend the operation of the decision being appealed against pending the determination of the matter if there are reasonable grounds for doing so. Disclosure of information. PIA kicks in, and public access to information and all kinds of other things are going to play itself out, and you can go through that in your own time. I'm not going to read through that. Suffice it to say that if you want, and this is also something not always understood by everyone, if you want a report or access to information held by a state department and you have a vested interest in that information, then you have to apply formally through the PIA, to get access to that information. If it is found that you are not someone with a vested interest, you will not be given access to that document necessarily. And also other parties, relevant parties, parties that have a vested interest must also be consulted before that information is passed on, in short. This applies to an inspector, where an inspector, in terms of disclosure of information as well, no person shall disclose any information concerning the affairs of another person obtained in the carrying out of specific functions in terms of the Act, except if the information is disclosed in compliance with the provisions of any law for the purpose of the administration of justice at the request of the Health and Safety Rep or Health and Safety Committee entitled thereto, where such request is made in writing, clearly specifying the reasons for the request, where the information is disclosed to enable a person to perform any function in terms of this Act, or where the person is ordered to disclose the information by a court. And I've also indicated throughout this new bill, there are places where the bill now says you have access, or you can have access, or you should have access to that information. Now we get to the part that I've been driving towards as well. This part that deals with administrative fines. You will know that there are two things. Excuse me. Good thing I'm not at the event today with a group of people. So this is what it's all about. When an inspector comes to you currently, if they come to your workplace, they find something wrong in terms of the Act or the regulations. In terms of the Act, they could submit a case to the courts immediately and recommend a prosecution, such as, for example, the absence of health and safety reps, health and safety committee, because I'm a stickler when it comes to structure. You don't have structure there, then you should be taken to task on that matter. Now, let's just look at that quickly. We will recommend a prosecution to the NPA they will consider it and they'll let it go through their processes if they deem it necessary and we fulfill all the obligations in terms of law. That is the one aspect that doesn't fall away when the bill comes out. There is an addition to the whole legal framework that we follow when it comes to doing inspections now, and that's called administrative fines. And you're going to see how this works. So the schedule that I spoke about early on when we were looking at this thing, we're going to get to that in a moment. Administrative fines. If a person commits a breach of this act, the inspector may, by written notice to that person, impose an administrative fine in accordance with Schedule 2. An administrative fine may, instead of a criminal prosecution, that's the other process, be imposed on a person who becomes liable to prosecution for any breach of this act. An inspector shall serve a copy of the written notice contemplated in subsection 2 on the employer, self-employed person, or person who conducts a business or undertaking concerned. The amount of the fine stipulated in the notice referred to in subsection 2 may not exceed the amount prescribed for the offence and which a court would presumably have imposed in the circumstances. An administrative fine imposed in terms of subsection 1 shall be paid to the Director General of the Department of Employment and Labour on or before a date stated in the notice referred to in that subsection. Sections 56, 57, and 57A of the Criminal Procedure Act, you can read that. Criminal liability: an employee, chief executive, manager, agent, or employee commits an offence by contravening or failing to comply with the provision of this act, thereby causing a person's death, permanent disablement, or illness. Chief executive officer, manager, agent, or employer of the employee commits an offence by performing or omitting to perform an act if the act or omission falls within the scope of authority or employment of the employer or employee concerned. Hindering of administrative justice: a person who hinders or obstructs an inspector in the performance of the inspector's functions. Now, doesn't matter who it is. It could be for argument's sake, it could be the SAPS, it could be any employer, it could be, as we had at one company, it could be a group of employees. If you obstruct an inspector in the performance of their functions without good reason, etc., you are going to possibly, you will be committing an offence in terms of this act, and you could possibly be recommended for a prosecution in terms of this. Refusal or fails to comply with any requirements or request made by an inspector in the performance of the inspector's functions, persuades an inspector to accept a bribe, or assaults or swears or victimizes an inspector in the performance of the inspector's functions, they commit an offence, and that must be very clear. No person may prevent an inspector from entering the premises where work is being performed during normal working hours, which would be an offence if this was done. Of course, if the inspector doesn't have a card, which are required to have, then you would be justified in not allowing the inspector in. Furnishing false information: a person who willfully furnishes a record, information, application, or other document, or makes a statement which is false in any material respect under this act commits an offence. Failure to attend meeting, inspection, investigation, inquiry when directed or summoned: a person who, having been directed or summoned to attend the meeting, inspection, investigation, or inquiry given in terms of this section, respectively, without sufficient cause, fails to appear at the time and place specified or to remain in attendance until excused. You know that these things are there, however, they are set out under a very specific section. You know that there's a long piece that's set under section 38. This, however, has split it all up. So you can go through it and you can see what an offence is and so on. 37F. A person who commits an offence and that person contravenes or fails to comply with any provision of this act, condition of an exemption, which is quite significant, requirement to produce a book, item, document, or thing under the person's control, and request to answer to the best of the person's knowledge and ability any question which an inspector may put to the person. A person commits an offence when the person willfully furnishes to an inspector information which is false or misleading. And so I go through this because this is quite an important area also for you to be cognizant of. And for me, if you don't know this part here, what is a contravention, and you do find yourself facing a prosecution, it will be because of your lack of knowledge on this. Now, the reason why this is added and looks as if it's new, it's only because section 38 and so on has been split up and has been given a different section numbers, if you like, as I've read through and shown you up to now. So penalties then, a person convicted of an offence in terms of the sections indicated in Schedule 1. Remember, Schedule 2 is administrative fines. This penalty is issued and so on in Schedule 1 may be sentenced to a fine or to imprisonment for a period not exceeding the period mentioned in the Schedule 1. A person convicted of an offence in terms of this act, for which no penalty is otherwise expressly determined, may be sentenced to a fine of 100,000 rand or imprisonment for a period not exceeding 1 year or both. This is very specific. A person convicted of an offence in terms of this act for which no penalty is otherwise expressly determined. In other words, where Schedule 1 and Schedule 2 is stated, it's clear what the offence and penalty is there. And that won't apply, of course. I'll just quickly put this also in a bracket for you. Wherever at the trial of a person charged with a contravention of section 22, and you'll remember it's where I mentioned that foot squirts issue, it is proved that the accused sold or marketed any article, substance, plant, machinery, or health and safety equipment contemplated in that section. It shall be presumed until the contrary is proved that the article, substance, plant, or machinery, health and safety equipment did not at the time of the sale or marketing thereof comply with the said requirements. And that is why I put it in a yellow block specifically so that you can see the importance of it. And we discussed that in a little bit of detail in section 22. And we're getting to the end shortly. Something quite important, an application for exemption shall be finalized within 30 days. So you have something that is clearly set out there, and I thought I'd just mention that. Something that is quite relevant that you need to be aware of, which I'll just quickly take you through. A provision of this act or a condition specified in any notice or direction issued thereunder or subject to which exemption was granted to any person under section 40 shall not be affected by any condition of any agreement, whether such agreement was entered into before or after the commencement of this Act or before or after the imposition of any such condition, as the case may be. Very, 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 very important that you take note of this. Many a times you're signing contracts, you're going into all kinds of things, and so on and so on, and you think that the Act and its regulations are not do not have the authority over those documents, and yet it does. So be mindful of that. And there's been a change in a certain degree there. So you might want to be cognizant of that when you do your contracts. Early on, I touched on this whole issue of the classification and labeling of hazardous chemical substances in the workplace. I'm reminding you that that is the GHS issue, and that it also finds its way into the Act, and more specifically, as we covered, I think it was in section 22 earlier, the consultations and negotiations to conclude collective agreements between an employer and employees and representative trade unions on matters of health and safety. Another issue that you need to be mindful of is that there's more involvement in terms of the unions and also an inclusion in collective agreements when it comes to health and safety, where these unions are in existence, of course. A regulation may in respect of any contravention thereof or failure to comply therewith. Now, I want to remind you of something, and I've put a cross next to it and a line through the area in square brackets for a very good reason. Currently under section 43, it refers to the minister making certain types of regulations. And when this bill comes in, it will play a bigger role. Now you'll see that where there's a reference currently to 200 Rand, at the back of every regulation, you'll see reference to 200 Rand. So if a contravention is ongoing over a period of time, that will be seen as a continuous non-compliance, and it can add up quite extensively. But look at this change. Look at the change that has been introduced now. A regulation may in respect of any contravention thereof or failure to comply therewith prescribe a penalty of a fine to a maximum of 5 million Rand or imprisonment for a period not exceeding 5 years or both. In the regulations, it is no longer an issue of 200 Rand or whatever the case may be. There is a major change coming, and obviously we are going to see with the challenges that may take place, how this whole thing is going to pan out. But the world of health and safety officially changes once this bill comes out. The minister may by regulation specify offences in terms of this Act in respect of which alleged offenders may pay a prescribed admission of guilt fine instead of being tried by a court for the offence. Occupational health and safety standards, and early on I remarked that there's something we'll quickly discuss. A South African national standard or any provision thereof that has been published in terms of section 28 in respect of a commodity, product or service which may affect the health and safety of, referring to the title number. So you can see that there's a square bracket there, which means that there's a certain part that's going to be taken out, but it says that the minister may by notice in a gazette incorporate the regulations. In the regulations of South African National Standard. Now, I'm going to leave this one because This is currently there, but check the change that has taken place there in the square bracket, the same in sub 2, but there is a very important point that's coming up. If the South African National Standard or a provision thereof contemplated in subsection 1 is amended, the amended South African Standard is deemed to be incorporated. Any South African National Standard or any provision thereof incorporated in terms of subsection 1 may be withdrawn. Any South African National Standard incorporated in the regulations under subsection 1 shall not, for the purpose of the Act, insofar as it is repugnant to any regulation under section 43, be deemed to be a regulation, but not before the expiry of 2 months from the date of incorporation thereof. And again, that square brackets means it's taken out. There. And take note about the standard. The future of standards rests with the South African Bureau of Standards approving basically all standards that are going to be incorporated. We are not going to approve or have in our standards any overseas standards marked as an overseas standard. So if you were to get a register of standards from me, which I give to people from time to time that request it, then you'll see that in terms of the current standards, there are a lot of overseas standards, especially when it comes to things like pressure equipment regulations and so on. So now we have a change. We are saying that no longer is that going to be the case. Things are going to change in respect to standards. Approved inspection authority, again, we looked at the definition earlier at the beginning of this presentation. The Chief Inspector may in writing approve an organization that has been accredited by SANAS in terms of the accreditation for conformity assessment, calibration, and good laboratory practice as an approved inspection authority for specifically defined work. And early on I said to you, you can have several accreditations and approvals, but you can't have one and do many get accreditations. Let me just rephrase that. You can't have one approval and do many or a lot of different types of work, if you like. Under A, conduct investigation, test sampling or analysis as the approved inspection authority may consider necessary and make specific findings purporting to be objective findings as to the health of any person, safety or risk to the health of any work, article, substance, plant or machinery, or of any condition prevalent on or in any premises, or the question of whether a particular standard has been or is being complied with respect to any work, article, substance, plant or machinery, or with respect to work rather, or a condition prevalent on any premises or with respect to any other matter. And by issuing a report stating such findings to the person to whom the service is being rendered. And this is a problem currently. AI is not making recommendations. People are dying out there, and there's a game in some cases that's being played by some people in relation to giving the Department of Employment and Labour access to information that allows us to properly advise and do what is right. The notice is not your biggest problem. When there is a problem out there, it's when we have to come out and do an inquiry or an investigation. And we now get access to the information, or we can request access to the information, or we can do an independent study with regard to the matter. So here's a bit of a change in terms of the way we're moving forward and the way things are seen currently versus what the future is like. The Chief Inspector may at any time request information from an AIA in a prescribed format for the purpose of the administration of this Act, which means that when it says prescribed, it means it's something that we'll provide guidance to you on, number one. Number two, early on I said to you that part of the AIA stuff is here and the other part is going to be in the general administrative regulations when this thing comes out. The GAR will be amended accordingly and changes will be effected as well. An approved inspection authority may be required to operate within a prescribed guideline as may be determined by the Chief Inspector from time to time. An approved inspection authority shall be subjected to an annual audit by an inspector. An approved inspection authority shall, in the prescribed format, report to the Chief Inspector every 6 months on all activities relating to the approval granted and all recommendations made to the employer. So there's conditions that are set. Chief Inspector may, in writing, at any time withdraw the approval of an approved inspection authority, which means that you will not be allowed to operate. You will have accreditation, but you will not have approval. And for issues that are listed in the regulations, you will need approval in order to do that. So it's more than just having accreditation. Once we withdraw it for whatever reason, and obviously we need to provide our reasons as well, your bread and butter effectively will be withdrawn. We get to the last part. A magistrate's court shall have jurisdiction to impose any penalty or to make any order provided for in this Act. The Labour Court or High Court has exclusive jurisdiction to determine a particular dispute about the interpretation or application of any provision of this Act, except where this Act provides otherwise. You will see that in terms of, for example, an appeal being granted or a request for an exemption, whether or not an exemption will be given and the employer feels that they must get an exemption for whatever reason. But very definitely an appeal is also coming under this particular area. Then the other aspect that you need to be aware of is we do have challenges. And in one particular big matter for us, the court said to the employer concerned that they had not dealt with the issue that was raised in terms of the Occupational Health and Safety Act, and that they had not, in fact, consulted with the Chief Inspector on the matter. And therefore, the court, with costs, sent them back to go and deal with the matter. So these sort of things can become expensive without it having to go the route of a compliance and non-compliance issue and so on. Now, you can see there again, stating of case to the High Court. If any question of law arises concerning the application of the Act, of this Act, the Director General, at the request of a party with sufficient interest in this matter, state a case for decision by the High Court. The DG shall set out in the stated case the facts that were found to be proved and the view of the law which was adopted in relation to those facts. The DG, if the DG has any doubt as to the correctness of a decision given by the High Court regarding a question of law concerning the applications of this Act, the DG may submit such a decision to the Supreme Court of Appeal. And then we get to the last bit, of course, Schedule 1. And you'll remember what Schedule 1 is. These are the issues that were raised under penalties. You can see there 2B, 8, 9, 10, 12, 13, 14, 15, 16, 17, 18, 3, 17, 1, and 17, 4, 22, 30, sub 2, 31, 1B, 34, 36, 37, 38, 40, 41, 42. 38, 40, 41, 42. 38, 40, 41, 43, 44, 45, 46, 47, 48, 49, 50, 51, 52, 53, 54, 55, 56, 57, 58, 59, 60, 61, 62, 63, 64, 65, 66, 67, 68, 69, 70, 71, 72, 73, 74, 75, 76, 77, 78, 79, 80, 81, 82, 83, 84, 85, 86, 87, 88, 89, 90, 91, 92, 93, 94, 95, 96, 97, 98, 99, 100, 101, 102, 103, 104, 105, 106, 107, 108, 109, 110, 111, 112, 113, 114, 115, 116, 117, 118, 119, 120, 121, 122, 123, 124, 125, 126, 127, 128, 129, 130, 131, 132, 133, 134, 135, 136, 137, 138, 139, 140, 141, 142, 143, 144, And if you were to take, let's take for argument's sake, and please, I'm just going to take it to show you how it's working, nothing else other than that. I think the big issue that you need to be mindful of is there's under the second row under section 8, there's a 5 million 5 years. Under 10, there's a 1 million 3 years issue. Under 13, there's a 200,000 Rand 2-year issue. Under 22, section 22, there's a 500,000 Rand or 3-year issue, and so on and so on. So I've been indicating this all along. Take note of what's coming. There are big issues on its way, and here it is. Schedule 2 then, and let me explain how Schedule 2 under administrative fines works. Let's say, for argument's sake, the inspector comes to your premises, and the inspector picks up on section 19(1), section 21, section 25, section 29, forget 25, 29(3) for argument's sake, and any one of those. The inspector comes to your premises, if it is applicable to you, and just bear with me quickly, I want to make the point. If any one of these things was to be tabled as a non-compliance issue in terms of administrative fines, while the inspector is there, any one of or any number of these things, if they are found to be not complied with, then you will be required to pay immediately. You'll be required to pay the amount, or within a certain time frame, whatever that amount is. So it's 5 times 50,000 Rand. Right? 5 times 50,000, that's what? 250,000 Rand that you'd be required to pay. It's even worse than having the current system in place, where you'd be you'd fail to comply with the notice. The inspector would draft the documentation, send it to the prosecuting authority, and the prosecuting authority would make a decision on the matter. Now, in both the processes, there is an appeal process that is allowed and does play itself out, which you are allowed to take advantage of course. So let's say you were to appeal this and you were successful. If you're not successful, you'd have to go to the High Court if you're not satisfied with the decision of the Chief Inspector. Once it goes there, if you lose the case, you end up paying what you are required to pay and whatever else the court decides you must pay. So I just wanted to put those two systems in front of you and tell you that when an inspector comes out to your premises, you could find yourself standing in front of one of these systems if you do not comply, paying either Schedule 1 or Schedule 2. Or you could end up paying both Schedule 1 or Schedule 2. In my opinion, the money would be well spent rather just complying. So the case for complying is much stronger. As I end my presentation to you, it is clear that the case for compliance is stronger today once this bill comes out and is assented to by the state president, than it would be. Look, it's easier currently than it would be going into the future. I think with that, I'd like to thank the CEO of Saiosh and his team for always being open to welcome us to participate as partners in this issue. And also in this particular case, can I thank Mr. Garth Hunter as well for presiding over the panel discussions. CEO, over to you. Thank you very much.
Thank you, Mr. Zana, for your time spending with our members and going through the bill. I'm sure the members will agree that it's one thing just reading through the bill, and that was not the purpose of this. I really appreciate you explaining and adding to certain sections that you underlined and highlighted to give some substance to it and also explanation to it. I think it's clear. We certainly appreciate your time and effort. Obviously, there were hundreds of questions flooding in. As I indicated in the beginning, it's virtually impossible to go through them all. We have them recorded. Saiosh will add all those questions to our workings. When I refer to our workings, I indicated in the beginning that Saiosh has formed its own technical committee with some advocates that will serve on it as well, to assist the department by submitting a comprehensive set of decent comments on this. It goes without saying that the more eyes that looks at this document, you will pick up something. I think fundamentally, if I may just say that we as OHS professionals has been calling for this for some time. I don't think we as the safety professionals will in any way feel that aggrieved with this bill. Just looking at the fines, and someone made a very valid comment the other day and say, yes, the fines are massive, they increased, and it should be like that. We're far lacking behind other in the world with fines. But someone made a very valid comment. If you just look at the National Environmental Management Act fines, they are more in most cases than this in any case. So I believe that the bill is well written. There's some excellent inclusions in there. Just to come back then to some of the questions, I kept on speaking in the background with Garth Hunter, one of our chartered members, to say those questions that we believe either consolidated, and I think we came up with about 5. So with your permission, sir, if I can hand over to Garth, Garth, and then maybe just pose those 5 odd questions to you. And I assure you we're not going to put you too much on the spot with these questions. Thank you, Garth.
Good afternoon, Tibo. How are you?
I'm fine, Garth. Thank you, man.
Good. Let me get started. I've got there's so many good questions. There's such a lot of detail that took us a lot of looking through to really understand which the best questions are, but let me fire away. So these are just an amalgamation of questions from different people. So the first one is the definition of the employer in the current Act specifically excludes labor brokers, whereas the proposed definition does not specifically include labor brokers. How will this impact labor brokers / skilled supply organizations?
I think from our perspective, and one of the big issues, and I think you'll be aware of it from our perspective now, and this is my feeling on the issue, an employer is an employer. If you fall within the definition of that employer, then you are going to have to respond to it. So even now, we are not, if you're not complying as a labor broker now, we are finding ways to challenge that sort of, let's say, discrepancy, if you like, because there is a feeling that labor brokers can do what they want and they are not going to be held liable. And we, for me, if you're not offering decent work to people, you shouldn't be around, you shouldn't be operating. And I think even the workers themselves don't want to work in an environment where they cannot work optimally because they're not going to feel like they've contributed like they should have. So if anyone feels strongly about us putting something in around labor brokers, we can either put it in the guideline because it's around what I'm saying to you, or we can maybe even include it, and that could be part of the submission of someone with regard to their submission, if you like.
Thanks for that. So the next question is that we note that newer regulations, such as construction regulations, asbestos abatement regulations, they define that they use the term competent person, whereas the Act doesn't specify the competence requirements of the person carrying out the risk assessments required in terms of the Act. So maybe you could just explain just how you view that.
Look, this is one of those areas that I think has developed over time, because if you look at the whole definition, if you look at several of the definitions in the regulations around competence, you're gonna see over time how it's evolved. So I think there is maybe you see, one of the things about the Act, you can see how long it took for this one to actually change as well. So having competence in the regulations, which are more specialized in relation to what it would like to achieve, I think what we need to do maybe is put something in the general admin rigs if we're going to put something somewhere. So at the moment, as I speak to you, several of the regulations are under review. And I say, even the old ones, your general safety regs and so on, environmental regulations for workplace, all these things are under review. And if people feel strongly enough about any of these issues, they're more than welcome to put them in there. Competence in the Act, I think it's going to tie us a bit up if, and this is what has happened, the world of SAQA and CETAs have changed so that we haven't had an opportunity to move together. So we find ourselves in a situation where we sometimes have to, where we might be leading and sometimes lagging in terms of certain issues. So in terms of competence, I believe it's an issue that over the next 10, 15 years, it's going to evolve further when we talk about Internet of Things. And, even now we are referring to, what is this, IR4? We now, what is this IR? Industrial Revolution 4. We're facing that phase.
The fourth industrial revolution.
Yeah, but already we are looking at Industrial Revolution 5, or IR5 is already playing itself out, and I'm preparing my people for that. We talk about 5G and the concerns around it. We haven't even touched the type of problems that's going to come out of your 5G, and now they're even referring to 6G already at this particular juncture. Some of the things from a medical point, they don't want to admit with regard to 5G and even 4G and the effects of electricity on our bodies and so on and so on. So I just want to put that out there, that it's something that is going to evolve, and I don't think that we should put it in the Act or anything. I think the regulations, we can evolve it over time and we can see how it pans out.
Thanks, very comprehensively answered. I'm sure our members appreciate that. So this is, for me, is one of the big ones, is that, and perhaps even surprising, is that using Section 16 as example, and we've come to the very backbone of the OHS Act for many years, right from actually the MOS Act, has actually been the term reasonably practicable. And so using Section 16 as an example, and it's removed in responsibilities, respect to the responsibilities of 16.1, and it appears that the responsibilities 16.1 are not subject to reasonably practicable. And I'd suggest that in doing so, it doesn't give consideration to the resources available to the CEO. So the question is, how does this weigh against the reasonable man approach, which is fundamental to law?
I think as with the development of law itself, and obviously as the arguments come in, and hopefully the legal fraternity will input into it as well. But the situation that I'm prepared to put out there, and this was a discussion that I participated in on another piece of legislation. You take training as an example. Should training really be up for discussion? when it comes to people. In other words, you add the term reasonably practicable before it. And now you come as an employee and you say, I didn't have enough money. I didn't have that. What we taught them is what we knew, or whatever the case is in terms of the 4 criteria. So for an employer, regardless of the fact that it's not there, and the employer was to put that to court, the court would obviously open itself up to listen to what the employer is saying with regard to the responsibilities. But in doing so, the employer would open him or herself up to the types of things that they wouldn't like to come out in an environment like that. So for me, the excuse is taken away, and the employer is forced to think thoroughly through everything. And if there's really no way they can comply, they obviously come back to the Department of Employment and Labour and engage us on the matter. And you can see the risk issue is tied up right throughout. So, yeah, so it's not a case of there isn't anything. It's a case of how well have you done what you had to do, and how well have you put in place everything you had to. And if there is any gap, you really didn't know about it. I mean, that the court wouldn't close itself off to a reasonable issue. So in this particular matter, I think the law applies even outside of the occupational health and safety sphere, as it were. There are other aspects of law that would kick in that the employer would rely on.
Then the next question is that one of our participants asks, does the 16.1 need to have direct control of the person they delegate to in terms of 16.2, or can they delegate to any person in the organization, even if they don't have direct knowledge of the functions of the person, such as in the case of a multinational organization, which is multiple levels deep? And then also perhaps tied to that is the issue of the 16.2 actually using other sections of the Act or regulations as actually sub-delegations. How do you view that?
Maybe there's some question that I must let you answer.
No, that's why you're the Chief Inspector.
But look, this is one of those issues where I'm going to throw it back and say, does it need to be changed? Does it need to be tightened up from that perspective, from a multinational perspective? And if so, how would you go about doing it? In other words, input, give us your side of the coin. Now, the one thing that has come up without fail over the years is what is direct control? And that is, I'm going to say to you, it's a tricky one, because we have situations where people are saying they're being managed from overseas. And I acknowledge and I accept that. However, change the Act then, or provide us with the input that allows us to manage what's happening. However, legally, there must be someone legal here in South Africa that's going to respond to legal matters regardless. So, and we're going to insist on it. How does the Act need to change? Now, direct control, these things are not, the duties that we are talking about are not things that must go low down in the organization. And that is what we are going to find. It is a responsibility at a level sufficient for us to manage health and safety. And it could be different business units. You don't need to give off these duties. And if you do give them off, it must be well thought out. Further sub-delegating to another level is not going to be allowed in terms of the bill, but come out with a different format. That is what I'm trying to request everyone. I've requested big organizations, give me another way of thinking of this. And up until today, I have not got that. The other thing also is that people do, Garth, is they tie it to positions. Section 16.2 gets tied to a position. with one organization, we said to them, stop it. These duties are specific. Don't tie them to a duty, because now they start talking about cost. Why must we worry about the fact that it's costing you more because you want someone else to carry something else, which was never the intention in terms of the way you're going about it? You see, this thing becomes a lot more complicated. So we're open to it, but we're looking for a structure. And what I'd like people to think about is also, what is it that's new that COVID has introduced in your workplace? Because if you're working from home, how's that going to influence these things that we are talking about in relation to the Act, as opposed to the regulation, like the hazardous biological agent regulation? So direct, I think if you go and look up the definition in the Oxford Dictionary, which is what we would look at, and it would tell us something, and that would be how we would be viewing direct control. There's no definition in the Act, unless someone would like to offer a definition for direct control. We could consider it. But right now, direct is direct in terms of how it would be defined.
Yeah, so you offered it. I think that, thank you for offering, I guess, to people out there, come up with another structure is what you're saying, or propose one, and you'll look at it. I do think that for multinational, I still work for multinational, it is difficult, and perhaps identifying the functional head. I speak now and then as an ex-inspector, and know then that as much as you give an alternative, then you then ask yourself as a chief inspector, well, how do you avoid that then, that way out being actually then abused? Which is really why you've actually come down to actually narrowing it down still to the 16.1, 16.2 structure. But yeah, so let's actually then get out there, get everybody together, put the ideas forward, and you'll look at it. Thank you. The next question is then, can an inspector just issue a fine in the same way they would a notice? And they ask, is there additional adjudication approval process to be followed by the inspector? Such a process may include oversight by the Department of Justice. The reason for this is the oversight role played by the courts has been removed. So there's a need to understand the structure replacing it.
Yeah, I'm counting how many questions you asked me. I think we
I'll tell you, liking my questions.
It's question number 4, Mr. Zana.
A quick one on that one is, look, there are going to be two systems playing itself out. Before the inspector indicates whatever the administrative fine is, it has to go through the provincial chief inspector. From the provincial chief inspector, it's going to go out to the employer. The employer will then have an opportunity to appeal and so on. But there will be a dual system playing itself out. If there are any other aspects, remember that this particular bill went through the state law advisors. In our case, we also have quite a big number of lawyers that now work in the Department of Employment and Labour that work with the inspectors. So any aspects that we face out there will obviously go through a decent legal process before it goes to the courts itself. In terms of the courts changing anything, we would obviously need to make sure that we are aligned to whatever's happening at that level, so that we ensure that we comply with what is happening there. Right now, okay, what I'm saying to you is, this is what we are putting out. State law hasn't come back to us and said to us, no, this is not fine, or whatever the case is. So from our perspective, it will add also, whether or not we want to, it's going to add an slight additional burden to our system. However, if you look at the administrative fines, it's not going to go the winding process or long-winded process. This one is hopefully shorter for everyone. except when it gets to the appeal, of course. But it will go internally. It's going to go through a process as opposed to the serving of a notice currently. That will go out immediately to the employer, but the other one will go through an internal process before it goes out.
Okay, thanks. If you don't mind, I'll ask two short questions, but I don't think as difficult as the one I've just asked. So the Criminal Procedure Act states the payment of admission of guilt fine will be the same as being convicted and sentenced in court. This means an accused will have a criminal record. Is this your understanding?
Say that again, God, sorry.
So the Criminal Procedure Act states that the payment of an admission of guilt fine will be the same as being convicted and sentenced in court. This means an accused will have the criminal record. And so basically, if you pay the admission of guilt fine, you have a criminal record. Is this your understanding?
Look, God, my previous understanding on the issue of admission of guilt is that there was nothing like that. If it has changed, it's something obviously I'm going to need to get up to date with, but that was not the case. That is not how I understood it. However, I think this whole thing needs to come to a head now, because we're dealing with people's lives here. I'll never forget years ago, a 19-year-old had his arm chopped off, 19 years old. What is the future like for someone like that? People who die, while they are young, even if they're old. I've had a couple of old guys that are on the verge of retirement die that I went out to go and investigate as a young inspector. I mean, it's crazy. I think stop worrying about the fine system. Stop worrying about non-compliance. Worry about complying so that people can get home, because this non-compliance system won't affect you if you're complying. Simply put.
Thanks. The last question, and it's just an administrative question, is that when do you expect the bill then to become an act?
I'm gonna put it out there and saying over the next 18 months. Not gonna take longer than that, because there's gonna be a push at all levels with regard to getting this thing out. So I believe that within 18 months, if we finish the process fast with regard to the public comment phase, then it goes through all its other processes within a short space of time. From our side, we'll push as we have been doing, and then get the thing out. So if we get it out, if we don't do it before an election period, then it's going to obviously be delayed by an election period. You see where the challenge. I'm stating you what the real challenge could be. If it happens over that period, we're going to have a challenge.
Thank you for entertaining my questions, and I know there was slightly more than 5, but I'll hand over. So thank you, appreciate it, and hand back over to Niels. Thank you.
Thank you, Garth.
Thank you, Garth. That's for that very good reason that I've appointed you to administrate, or rather to facilitate the questions, because you know how to not manipulate, but how to keep the Chief Inspector online. Sir, if I can ask you just to remain for a couple of seconds online, I just want to do some closing comments, and then finally thank you for your presentation. Just a quick reminder to our members that this whole session was and is recorded, and that members will be receiving the link to the recording so that you can go and look at it again, listen again, and obviously share it in your workplaces. Also, members, you can claim 1 CPD point, Saiosh CPD point for this. So please visit your profiles and claim the CPD points. Thanks to Garth in the background for monitoring the questions and asking the questions this afternoon. Thanks to our membership and communications manager, Gareth, for the technical aspects. I've attended a lot of webinars, and it's sometimes chaos. And these ones of Saiosh, I must admit, is run smoothly and well controlled. So thank you for that. Just in final closure then, also that was broadcasted on YouTube. I think we had a record number of viewers. I think in total Mr. Zana, we just had short of about 1,000 people watching on YouTube, as well as the live webinar this afternoon. It just shows the importance of this document or this bill and the interest our members have. And I can assure you that we will submit great comments. In that, I just also want to then remind members that Saiosh has opened an official forum on our technical forum where you can go and post comments. We urge you to do it if you're not doing it formally through your employer. I think the department appreciate if comments comes collectively from large corporations or organizations and bodies like Saiosh rather than individual comments, although it's open for public comments. Just to appeal to our members while you're still listening to this, that when submitting the comments, just like we will be doing it to the department, is not to complain because it'll just be ignored, to say the fines is too high or the section is irrational or whatever the case will be. The way to submit the comments, like we will do to the department, is to quote the section, actually quote the section that is written in the bill, and then your proposed comment, in other words, your proposed changes, and then finally in the third column or the third aspect is your reasoning for that, or the explanation, what is the reasoning behind changing it. And that way we can then go through those comments and add it to our collective comments, which the technical committee will work over the next 2.5 months on that. So just a reminder that forum is open to our members, and you can please go and submit comments on that. Right, in closing then finally, Mr. Zana, thank you very much. We really appreciate your time. It was well received. Just looking at the numbers of attendance, we appreciate your support. You are honorary member of Saiosh. We are honored to have you as an honorary member, and we really appreciate that. When I contacted you, to immediately says no problem. You will do this presentation for us, and we can get the insights from the Department of Labor, Employment and Labor. We really appreciate that. Thank you very much. And in closing then, I would say thank you for all our members that attended this